The difference really now is that you'll get your interview with our defender, which Stephen kind of was last week, so that was interesting. With our self-defender, that'll be every Friday, and that's at 10 o'clock Eastern, I think it comes out. And then Gutowski Files will come out whenever Stephen and I have the opportunity to sit down and get together and discuss current events. And it goes out almost right after we talk, which is good since it involves current events.
Today's video is brought to us by Mantis. The Mantis family of products is integral to ASP staff building handgun and carbine skills and are your most economical and fastest path to improvement in your skills too. Whether you choose the X10, the Laser Academy, the Blackbeard, or use them all in concert, they will help your practice be more effective, efficient, and fun. Go check them out, pick up a unit, and thank them for sponsoring today's video.
We are recording this Monday, September 25th, and some of you can see, Stephen is wearing a Philadelphia Eagles jersey with a Super Bowl logo. For some reason, knowing full well that my beloved Redskins Commanders football team ate dirt yesterday against the Buffalo Bills. So he's just going to rub it in. I should be wearing my Commanders jersey, but I don't have one.
I don't know if you should be wearing it after that.
Who are the Eagles playing today? Oh, the Bucks, right?
Yeah, the Bucks. So
yeah, Baker Mayfield.
Yeah, I mean they're 2-0, but I feel like the Eagles should absolutely beat them. If they don't, it'll be.
I've never been a bigger Buccaneers fan than I am today. That's what I'm trying to get at. With all that said, Stephen, how was your podcast week? Who was on the Reload podcast, and what did you guys discuss?
Yeah, our most recent episode featured Cody Wilson of Defense Distributed. He's this controversial figure, right? He's the guy who printed the first 3D printed gun about a decade ago,
right?
And now he's introduced a new AI model that'll help you build a gun because ChatGPT and these other AI models that exist and run by large tech companies, actually, if you've ever interacted with them, tend to censor certain aspects of themselves. They're not allowed to talk about, for instance, how you build a gun.
Right.
So that's where Cody Wilson and Defense Distributed are coming in. It's pretty fascinating, obviously right at the edge of sort of firearms development and the gun debate. And I think it's a pretty interesting podcast.
And he called his GAT GPT. LOL.
Yes.
I see what he did there. It's pretty clever.
He's a
pretty
very
good branding.
media savvy guy, as you could probably imagine.
Yes, sir. So we are discussing a couple things here. One is a more current event than the other, but we're going to talk about, there's a couple of member exclusives over at thereload.com. If you're not a member, I recommend it because you get these member exclusives, and it's almost always really, really good. It's always really good stuff. What am I talking about?
Yeah, almost.
Almost.
What is this?
As long as Steven's involved. So there are two over there. One is by contributing writer Jake Fogelman, and it is an analysis piece. SCOTUS will have to weigh in on nonviolent felon gun rights soon. We touched on it a little bit last week. And then analysis newsletter from Stephen Gutowski, which says something similar. SCOTUS can't avoid the felon question much longer. So for people who don't know, what we're discussing here is whether or not moving forward, sort of nonviolent felons will be included in this, or should they be included in this? That's certainly an aspect of it. So if someone is, if Stephen goes out and cheats on his taxes and he's charged with felony tax evasion, does that mean he never gets to own a gun again? And there's a lot of good questions to be asked, and there's a lot of good points on both sides of this, I think. So Stephen, kind of give us an idea of what's going on. We talked about it last week, but there's more to talk about. We need this to get to the Supreme Court at some point to get this settled, right?
Yeah, absolutely. And I think it's going to end up there relatively soon. And actually, it could be settled maybe even sooner than people imagine. But yeah, Martha Stewart's always used as the sort of poster child for this. She can't own a gun because she has that conviction for insider trading, famously years back. And so she's a felon. But does it really make sense to restrict Martha Stewart from owning guns for the rest of her life because of that crime? That's sort of been a topic of debate at least in academia and in gun rights circles for a long time. And now you're seeing it play out in the courts after Bruin, right? Bruin sort of reset the whole case law for Second Amendment cases throughout the federal judiciary. And you're seeing a lot of these laws that had been upheld previously being questioned again. And this most recently deals with a case out of the 10th Circuit and a case out of the 3rd Circuit. They're very similar circumstances. In both cases, you had basically people who were very poor that were accused of fraud were convicted of fraud or pled guilty to fraud that made them felons. They were in Pennsylvania, the Third Circuit case. There was a guy who wrote or who lied about his income to get food stamps, and so he pled guilty to doing that, and he was sentenced to probation. He never served any time in jail, but because the punishment could have been more than a year in prison, that triggers this prohibition. Same thing with the case in the 10th Circuit, where a lady who was homeless wrote a bad check for less than $500. Kind of makes you, so the details of these cases might make you question some of our punishments for some of these things.
Right.
But similarly, she was not imprisoned. She was given probation. But again, because the punishment could have been more than a year in prison, she's been prohibited from owning guns for her life ever since then. So in the Third Circuit, the court ruled that the felon in possession ban was unconstitutional as applied to this guy who committed food stamp fraud in the 90s because there wasn't a historical tradition as required under Bruin to bar people like that from owning guns. They're not a danger to society is the idea. They're not violent, so they can't be restricted from owning guns. However, the 10th Circuit came down in the exact opposite direction, and they upheld this conviction and the law, basically relying instead of on a examination of history and tradition, just on dicta from the Supreme Court. Dicta is any time when the Supreme Court writes an opinion, there's sort of the binding aspects, the bottom line parts of the ruling, and then there's all the other things that they say. And that's what dicta is. So there's a lot of dicta in Heller that talks about how they're not trying to implicate by knocking down DC's handgun ban at the time. That's what Heller did. They're not trying to implicate felon in possession laws or machine gun bans or things of that nature. They talk about that in Heller. And so that's what the 10th Circuit used to justify upholding this law. There was another appeals court that went along the basically exact same line as the 10th Circuit. And so now you have this, what's called a circuit split. And that means that federal law is being applied differently depending on where you live, which is not a situation that the federal government likes and that the Supreme Court generally lets stand for very long. And so you are very likely to see this taken up by the court, perhaps in its own standalone case. Range is the one in the Third Circuit. That's what a lot of gun rights advocates are hoping is the next Supreme Court case. But however, I mentioned that they might get to this even sooner than that, right?
Yeah.
And that's because they've already got a case. We've talked about this before on the show, right?
Oh, Rahimi.
Yeah, Rahimi. Where
for the folks who don't know, tell them what's going on with that.
Yeah, that's the one where there's just a guy subject to a domestic violence restraining order, and he was found with a firearm after he was accused of committing a bunch of other crimes. But he challenged that prohibition, because if you're subject to one of these restraining orders, you can't own any guns while that restraining order is on you. And so he won his challenge at the Fifth Circuit, but then the Department of Justice appealed that to the Supreme Court. The Supreme Court accepted that case. That's going to be their next Second Amendment case. And it really deals with a pretty similar question as these nonviolent felon cases, which is, who can be prohibited from owning guns? You still have that sort of base level question, not really opined on by the court yet. And in answering it in Rahimi, you might well see them get an answer for the nonviolent felon situation. And there's a number of different competing frameworks for how people want to see them come down on this question.
Yeah, I think it's interesting. I have an analogy. If you'd like to hear it, maybe you can judge the whether this analogy is appropriate or not. Dicta versus an actual court decision. I always viewed it as the court decision is the movie that's released to everyone, and the dicta is sort of the director's editorial on what the movie's about and why things are the way they are. Is that an imperfect analogy? Yes, but I think it kind of gets the point across. Would you agree?
I think it's pretty good.
Yeah.
Yeah. I mean, the thing is that what you have to remember about dicta is that it's not binding. Right. So it's not something that the lower courts have to consider at all when they go to make the decisions.
Correct.
But in a lot of these gun cases, you've seen them for all kinds of different questions just default back to dicta from the Supreme Court, because the assumption is, well, the court has said this in the past, so they probably still believe that now. I don't know that that's even a good assumption after, because Heller was from 2008, right? So that, or no, 2004, right? Yeah, sorry.
I'd
It's
have to look it up.
even
I don't
further,
know, to be honest
it's
with you.
from even further back. And so maybe it's 2000. All right. I apologize. Off the top of my head, I can't recall which year Heller came down in, but it was a long time ago, and the court was very different at that point. You still had Justice Kennedy on the court, who a lot of people consider that language being inserted into Heller was to appease him. That's, the tea leaf reading, which you have to do with the Supreme Court a lot.
Right.
That's not a known fact, but that is what a lot of people assume when Scalia wrote that decision, who also obviously he passed away, so he's not on the Supreme Court anymore either. They think that this caveats that they put in about basically just saying that this specific ruling doesn't knock down these laws yet.
Right.
That's more or less what it says. This ruling is not meant to cast doubt on these they call them long-standing prohibitions. And, the Bruin does talk about how for a modern law to be constitutional, it has to be long-standing, or it has to closely match a regulation from the founding era. But I don't know that the Bruin court's view of what long-standing means
Yeah,
is
that's
the
the
same
question.
as the Heller courts.
Yeah, people
Because they're striking down a law in Bruin that was from 1910, and
Right.
these federal prohibited persons restrictions, they didn't start showing up until the 1930s. So, how long-standing that is, it doesn't seem on its face to match the Bruin standard. Some of these laws now they might, in terms of analogy to previous laws from the founding era, but that's the open question.
Yeah, and I think some people, especially the younger you are, you have a different concept of what is and what is not long standing. One of my favorite comedians, Eddie Izzard, he's a British guy. He comes over and he talks about London, growing up in London and England. It's been around for thousands of years, and he comes to America and people are like, this building in Philadelphia is well over 100 years old, and everyone's like, ooh, that's so old. Not really. Like, the FBI has barely been around 100 years, and people kind of have this idea the FBI has been here forever. It hasn't. I think what it comes down to for a lot of people like me, I tend to think in big chunks. I'm not a big detail guy. So why can't we just say, look, obviously, if someone's violent, if violence is part of their history, we prohibit them, and the other people we don't. The problem is we're dealing with the courts, and the courts have to get specific. They have to get into the weeds about all the possible ramifications of a decision. And so